Listening to Take a Stand with Damita Chatman, your host. Today I have the Superior Court judges and the solicitor, assistant solicitor. Watch us on YouTube, watch us on all social media outlets. Let me put this disclaimer out. Everything today is not the producer, but the host. So anything that is said today, charge it to me and not my guest. I want to thank you guys for coming out today to doing this show, and we just want to have some fun and talk to. I say Fulton County got the baddest judges in America. I'm gonna say that so y'all don't have to get in trouble. I'm gonna say it. Thank you guys for coming today. I'm gonna start with the Solicitor General, the Assistant, Mrs. Shelly Faulk, and everybody can introduce themselves, give them a 1 minute introduction, and then we're going with the show. Thank you guys for coming.
Thank you. So just to introduce myself, my name is Shelly Faulk. I am a Deputy Chief Solicitor General here in Fulton County, and I have the privilege of working for Keith Gamage, who is the Solicitor General of Fulton County. Our office handles the largest volume of cases in Fulton County. We handle misdemeanors, which are punishable by 12 months or less, as well as traffic offenses. And I have been a prosecutor for 20 years. And so it is really a pleasure to be here today. Thank you so much, Ms. Chapman, for arranging this.
Thank you. Judge Harris.
All right. My name is Melynee.
I'm sorry, Judge Leftridge.
Well, it's Leftridge, Harris, Leftridge, sometimes Harris. It's all of those things. But it's all good. It's all good. I'm Melynee Leftridge Harris. I am on the Superior Court of Fulton County, and I have the pleasure of serving on the bench with 19 other fabulous judges. I've been a Fulton County resident for about 33 years, if you don't count the 4 that I spent here as a Spelman student way back in the 80s, the good grand old 80s. We were talking numbers before we came on air. I've been on the bench in some capacity since 2010, when I was a magistrate before becoming a Superior Court judge. I was elected with the help of the people in 2020. I'm pleased to be here. Happy to be invited. Thank you.
Thank you. I'm going to give it to Judge Farmers, since in the old judge going to be last.
Well, I think I'm actually older than Judge Dunaway by a couple of years. So, but he and I did graduate law school together from Mercer in 1996. Same as your son, but different years. My name's Kevin Farmer. I've been in Fulton County since 1982 when I was in 9th grade. When I came down here and went to Riverwood. Shout out to my Raiders, just won the basketball state championship. Thank you very much. But I started as a public defender. I did some time as a district attorney, and then in 2018, I decided to run for judge, and I was thankfully successful. And this is my second term on the bench. I enjoy doing the work for the people. It's their courthouse. We just occupy it for them and help them where we can. Trying to do the people's work as best we can. We don't get to see Miss Faulk or her folk because we're in Superior Court and we do all the felony stuff. But we do deal with the DA's office almost exclusively. And I'm in family court right now, so I don't even have to do that. All I see is divorces and child support and custody proceedings right now.
Okay. Judge Dunaway.
Thank you for having us. Thank you for having me, Eric Dunaway. Born and raised here in Fulton County. I'm one of those Grady babies. APS for first kindergarten through 5th grade. Went to Fulton County school systems. I'm out in the city of South Fulton, Old Cliftondale Elementary. Then I went to what was then Westwood High School. I went to Westwood until we merged in '89 and became Westlake High School. It's still there on the same property. So I graduated from Westlake High School. I like to tell people I built the field that Cam Newton made famous. I was out there first, but graduated from Westlake High School in '89, went over to Morehouse College, had a family legacy there. Mother went to Spelman, uncles and cousins went to Morehouse. So I followed in the family legacy, went down, met Kevin at Mercer down in Macon. We spent 3 years together down there. Macon was amazing. It's even better now. Came back home to Atlanta, worked for the city of Atlanta traffic court, then the Fulton DA's office. Took a couple of years, went out to Paulding County, got a little bit of different experience out in Paulding County, came back inside of 285 DeKalb DA's office. And then in 2016, I stood before the people and ran for election for this position. Very fortunate and blessed to be elected by the people of my home county and home city. And I've been here since 2016 and now my 8th year on the Fulton County Superior Court bench. And we do have some great judges here, and so happy to be with them and so happy to be with you today.
Thank you so much. So I'm gonna say we got the product of the city of South Fulton on the judge. Great city. I understand, but South Fulton. Thank you guys for coming. Let me ask you a question, and I got Judge Donahue, so I'm going Dunaway here. So let me ask you, tell me, what has your experience been on the Superior Court?
It has been a great experience. I always, as a trial lawyer in the courtroom, I always wondered why some of the judges were cranky. Why were they angry and mad? I said, court doesn't start until you come. Everybody has to stand up when you walk in. If you tell a joke, people are obligated to laugh. And when you get hungry, you in court. So I didn't understand what they were cranky about. And now that I've had the job, I still don't understand why some of the judges were cranky. It's a lot of work, but my experience has been amazing. I've had some great colleagues, some great ADAs, and some amazing defense attorneys. And then learning getting in and being a part of the civil, dealing with contracts and some of the lawsuits. It's been a real experience, and I've loved it, and I still love it. And God and the people of Fulton County allowed me. I'll be here for a few years.
All right. What about you, Judge Leftridge?
This is my dream job. I mean, in short, I really, really enjoy the day-to-day here. Something comes up unusual almost every day. And that's one of the things I really, really like about it. Something challenging, something unusual on a daily basis, whether it be criminal or civil. I started on this bench as a staff attorney. And so every day I feel blessed and honored to be in this seat as a Superior Court judge. So I think Judge Dunaway said a lot of what I would have said. It's just a fabulous, challenging place, to be working. And I feel blessed and honored to be here.
Okay. What about you, Judge Farmer?
Well, I tell people that I don't have to go to work. I get to go to work. I want to go to work. I built my career about 10 years into my career. I knew I one day wanted to run for judge. So I started to learn different areas of the law. So when I got here, I would be familiar with the civil suits and the criminal stuff and the family stuff. I think Judge Dunaway did hit the nail on the head. This is the job that we strove for and we achieved. And I think we all like doing, providing an arena or an area of where folks can get their disputes heard. It's not always fun. And, you have to understand that when the people come before you, we're here every day. I think one of the important parts about being a judge is remembering the people that are in front of you. Nobody's ever happy when they have to walk into a courtroom, and they're nervous for the most part because they're not used to going to court every day. So, you might be able to get on their lawyers, but you got to take special care to not get on the litigants because they're just trying to get whatever their problem is solved. They're just trying to get their day in court. And, we are elected by the people. We are there to provide them a service, and that is to help them work through their situation. Everybody likes to try and settle stuff out of court, but at the end of the day, sometimes people can't, and we're kind of the last resort for those folks. And I think my parents raised me right to be fair, to listen. I'll read the pleadings ahead of time because I think we owe that to them. And you kind of get, oh, okay, I think this is what the case is going to be, but you still have to keep an open mind when you go out for the hearing or the trial, because sometimes different things come out, and you have to be willing to change your mind and go where the evidence takes you. And I love that. I get to go to work every day.
You're good. Now I'm going to say this. I didn't get a chance to kind of work with Judge Dunaway, but I met Judge Farmers when he was running and Judge Harris when she was running. And when I say they were awesome people, I knew if they got elected that they were going to be great in those seats. And I had a chance to talk to Judge Farmers during the school years of my son down there in Mercer, and he was a listening ear, and so for Judge Leftridge. And so I know we got some great people on the bench there. Miss Faulk, tell me, what have your experience, been down at the Fulton County Solicitor office?
Well, I would like to first say, Judge Leftridge, the time you spent at Spelman absolutely counts. I was there from 95 to 99, so it 100% counts. And so I'm lucky to be spending my 30th year next year in Georgia, and I couldn't think of a better place to spend my time. I will say that being in prosecution for as long as I have, I can truly say it's a calling. It's not a job for me. It is truly something I was called to very early in my career, and I just have never stopped being called to it. And so for me, especially working under Solicitor General Gamage, I've had an opportunity to really engage in the restorative justice aspect of this job, which I don't think we get to do enough as prosecutors. I think prosecution is typically seen as this job where you show up and you prosecute people and you put them in jail. But what Solicitor General Gamage has opened up is a new space where we can engage in things like our warrant clinic, which is actually coming up, where we are going to have individuals who have arrest warrants come and try to address those warrants so that they're not picked up. That's coming up on Saturday, April 13th. We also have our annual, it's essentially a record restriction event. And we hold that every year. This year it is on April 20th. And that is for anyone who wants to come in and have their record restricted. We're trying to give individuals a second chance, allow them to restrict their records so that they can engage in the community. They can get jobs. They can seek those opportunities, which are normally not afforded to people who have a criminal history on their record. And so those are aspects, as well as our pretrial diversion unit, which we are trying to, as early as possible, divert people in a way where we are still prosecuting those individuals who've committed serious offenses, but also trying to find opportunities where we can give people second chances. And that's something that I particularly enjoy about this office, because it's something that in the 20 years of doing prosecution, I don't feel like I've gotten enough of an experience with that aspect of giving people these second chances.
So let me ask you, while I got you there, is it certain criminal activity that you restrict, or do you restrict like the felonies, the driving under the influence and the weed and all that good stuff? What do you restrict?
Right. So because it is the solicitor's office, we handle misdemeanor record restriction. So we're looking at misdemeanor offenses. So for felony offenses, there are record restriction events that DA Willis hosts, but these are just misdemeanor offenses that we're focused on.
Since I got Judge Leftridge, tell me, the Superior Court, what do you handle? Do you handle the felony? What do you got? What do you handle under your?
Yeah, we're a court of general jurisdiction, which means that we are handling a whole bunch of stuff. In short, we handle civil cases that are rooted in property disputes. We handle family disputes. Judge Farmer mentioned he's in our family division. There are 4 judges of our 20 judges that are family court judges, divorces, adoptions, custody disputes, and things of that nature. We handle the felony cases. So our jurisdiction is really felonies and misdemeanors. We can handle both, but we have exclusive jurisdiction, meaning we're the only court level that can handle felony cases. And felonies are, of course, your more serious crimes like murder, rape, armed robbery, things of that nature are felonies. So we handle those cases. We, in the Fulton County Superior Court, we have a special sort of nuance as well. When someone elects to sue the state in a civil action, because this courthouse is located in the Capitol, we get those cases as well. So that sort of separates us just a little bit from our sister courts in other counties. So those are the things that we see most often here in
Okay.
yeah.
Judge Dunaway, tell me, explain to the people, Judge Leftridge hit on, but explain to the people when they come before the Superior Court, what they expect, what they should expect from that court system.
Wow, there's a lot because as Judge Leftridge said, we're a court of general jurisdiction, so there is a lot that we can handle. On the criminal side, by the time someone would get to Superior Court, means they should have already been had a preliminary hearing, a probable cause hearing, had a bond hearing, and the case should have been passed on by the district attorney's office through the grand jury process. So a lot has happened by the time it gets to us in Superior Court. But we get it. We have an indictment. We have what's known as an arraignment. At the arraignment, the person who is accused and charged, they get a copy of their charges. They can have the copy of their charges read to them in court. They are apprised of their constitutional rights. They are either appointed a lawyer, or if they've hired a lawyer, they have opportunity to hire a lawyer or have a lawyer appointed for them. And then after the arraignment process, there's some time for exchange of documents and discovery. And after some time period, 3 to 6 months exchange of documents and discovery, most of the judges have what we call a plea or final plea calendar, wherein the state and the accused, they have an opportunity to discuss the case and present a plea to the court, a negotiated plea, or the accused can enter a non-negotiated plea. And they, of course, have their absolute right, constitutional right to a trial by jury. If they cannot work out a plea, or they are maintaining their innocence, they have that constitutional right to a trial by jury. And then we put on a trial calendar, and where we call them in and select the jury, and the jury will decide the factual issues of the case. On the civil side, if a case is filed and the lawyers choose to file it in Superior Court, we have to make sure that that lawsuit is served on the other side. Once it's served on the other side, they also have a 6-month discovery period. And then we bring them into court on what's known as a pretrial conference. And sometimes there are motions, dispositive motions, summary judgment motions that we have to set down and hear those motions and arguments of the lawyers. And then again, opportunity to work it out, enter into negotiation and settle the case. And if they're unable to settle it, we have that pretrial conference and we get it scheduled for trial, and give them the opportunity, as Judge Farmer said, give them the opportunity to be heard. So hopefully coming into Fulton County, that's the process, at least in the civil and criminal arena. And we try to move the cases along as efficiently as possible, without violating anyone's constitutional rights.
Okay. Judge Farmer, you handle family court. So when it leaves the smaller court and come over to your court, it's more serious. So let me ask you, do you intervene when it comes down to just say parents and the children? What do you do, Judge Farmer?
That's pretty much exactly what we do. We have 4 judges on the family court, and Judge Leftridge said we're a court of general jurisdiction, which means we can hear everything. So we can hear everything that state court does, but there are some things that only we can hear. And domestic relations, family law, is one of the things that only Superior Court can handle. So it starts here. It doesn't even come up here. It's got to start here. And, I'll handle divorces. And, we volunteer it's a 2-year term on the family court. I did 2 years and then I renewed it. So I'm in my 4th year on family court, and I'm going to step away from it. Our rules, our judicial rules, after 4 years, you have to step away from it. But, we start with the divorce. And if there are kids involved, my job is to ultimately look out for the best interests of the children, because divorces, there's 2 parts. There's the kids, and then there's what we call the marital estate, which is the money. Now, when you say the money, sometimes it's assets. A lot of times it's people splitting up debts. They don't have the money, so you're kind of assigning who's got to pay what. And it's real unfortunate, because I tell the parties that the kids are the only ones I really care about, because literally in the code section, the law says the judge looks out for the best interest of the child or children. But I tell the folks, before we go to trial, that they're in control of their own destiny, and whether they're not going to be married anymore, but they're still going to be parents together. People have to learn how to co-parent, because their child or their children are watching them learn how to resolve conflict, how to resolve disputes. And kids learn by looking to their parents. And it's also unfortunate that I can guarantee that at least one of the parents in front of me is not going to be happy, because they're both asking for, they both want to have the most time with the kid. Nobody wants to have 2nd and 4th weekend or 1st, 3rd, and 5th weekend. They both want primary custody. And that it can't happen that way. There's only so many hours in the day. And then the problem is we have some judicial officers who handle, we have status hearings, 30 days, 60 days, 120 days, where we make sure that the parties are exchanging information and doing discovery, like I heard Judge Dunaway say, because you have to exchange all the financial information, bank accounts, W-2s, 1099s, retirement accounts, land, anything with an account number on it, you have to show it, because people like to hide money in divorces sometimes. But after that, if they settle the case, I never see it. The lawyers will send me settlement paperwork that's been signed by both their clients, and I'll review it and sign off on it. So by the time it gets to me, it already means they have not been able to work it out. They haven't been able to settle. Now, a lot of times they'll settle, once you see the whites of the judge's eyes, it gets a little more real when people are walking into the courthouse and having to come into a courtroom and have a stranger decide their fate.
Okay.
I try to tell them that my job is to really not be emotional about it, because I can't be. Because I see in divorces and child custody proceedings, emotions are real high and trust is real low. So I tell them I take the emotion out of it, and only time will rebuild the trust between the parties. And sometimes you just see the divorce and it's an amicable divorce and the parents do fine. But then I have cases where they come back every year, 2 years. Mom's not doing what she's supposed to do. Dad's not doing what he's supposed to do. The other party's not letting me see the kid, not paying child support, abusing the child. So I come in for when people want to modify custody or change their amount of child support. Somebody's making more money than they did at the time of the divorce, or they're making a lot less than they did at the time of the divorce, and they can't afford that child support anymore. So it's, every case is involves the same issues, but the facts are always different. And it's unfortunate that, like I tell them, at least one of you is going to hate me. You'll probably both dislike me when it's all over. And that's just an unfortunate part of family law. Because I know that both parents love their kids, but they can't both have them 70% of the time. 70 and 70 is 140%, and that just the math doesn't add up, and it's
Okay.
unfortunate. So,
Okay.
Ms. Chapman, could I piggyback
Yes.
a little bit
Yes.
on what Judge Farmer just said?
Yes.
I think the only time when we are assured pretty much that everybody is going to be happy is when we're marrying people or there's an adoption, everybody's smiling and happy and you feel good. I mean, I feel so good to do an adoption because everybody is so upbeat and it's such a beautiful thing. And then when we're swearing folks into the bar, that's another like really, great occasion. But everything else, I mean, we're sort of robed refs, robed referees. And, the calls we make, as Judge Farmer said, we're going to make both sides mad or one side, maybe unhappy. And it's the nature of the job,
Okay. Do you agree with the Judge Dunaway?
Oh, yes. I was, those three things are the joyous, happy events. Everything else, someone's walking away unhappy.
Let me ask you, I heard something on the radio this morning and it was talking about guardianship. When a kid turns 18 and needs that guardianship, someone to be over. And they was talking about how sometimes we can don't understand the way it works in the rules, and it's different guardianships. You can turn all the power over. Is that correct? Could you explain that a little bit? In guardianship, Judge Dunaway?
And Judge Farmer may be better at this one because he's in the family division. But I know with my nephew, when my parents had to get guardianship over him, and he was younger, they were able to get full guardianship so they could make all of his decisions for him. And I want to say they went through probate court, but Judge Farmer, am I right on that one? It's probate court, so that'd be Judge Kenya Johnson.
that's more of a probate issue. And if someone's over 18, you have to petition for guardianship, but they're, because they're an adult. You're going to have to show some reason. I mean, I guess the most famous case everybody looked at was, Britney Spears was in receivership or her dad had guardianship over her. And why? Well, he had to go in and show the court, hey, she's not able to handle her finances or handle her life. And, you've got to meet a burden of proof there. And then ultimately she said, hey, I'm tired of being your ward. So she went back and got out from underneath it. And then so usually that's folks with, either a mental or a physical disability. You can voluntarily, give guardianship to somebody. But that's going to be on a, again, a case by case basis.
Okay.
But we're not in a position where we can, I can't give you a hard answer there because it's going to depend on what what folks come to you with. But
Okay.
that is more down in probate court.
Okay. Miss Faulk, let me ask you a question. When you go into the expungement and you look back a couple years and you see that still thing on your record, what do people need to do to get that expunged off their record?
So first and foremost, I would encourage them to reach out to either our office, Solicitor General Gamage's office, or the DA's office. So it really depends on if the offense is a misdemeanor or felony. If it's a misdemeanor, which means it's punishable by 12 months or less, that's going to be our office, the Solicitor General's office in Fulton County. And if it is a felony, that's going to be the District Attorney's office that they would need to reach out to. As I stated before, we have a record restriction clinic actually coming up in career fair on April 20th. It's going to be from 12 to 3, and it's going to be in conjunction with the Cascade United Methodist Church, the Georgia Justice Project, Project Restart, and Trinity Presbyterian Church. And that will be an opportunity if you have a warrant, not a warrant, excuse me, if you have a history and you're not sure whether it's a felony or a misdemeanor, what I would just encourage you to do is come down to 3003 Howell Mill Road Northwest in Atlanta, Georgia, for that event on April 20th, which is a Saturday from 12 to 3. Come down, come talk to us, see if maybe we can help you restrict that record, or we can direct you to the DA's office if it is a felony. So what I would just encourage anyone listening to this program to do is just come on down to that event, or if they aren't able to make it to that event, just to call the Solicitor General's office or the District Attorney's office, and we can point you in the right direction.
Okay. Let me ask you a question while I got you. What cases would make a case come over to you guys? Do it go through the DA first, or what do it go before it get to you guys?
So we handle misdemeanor offenses. So normally the misdemeanor offenses do not go up to the DA's office unless they are what we call recidivist offenses. For example, somebody has a number of prior types of offenses, theft by shopliftings or some family violence, batteries, or others. But either they come in as a misdemeanor through our jail, or they come in through the different municipal courts all around the county, and those are called bind-over cases. So let's say you have a traffic offense, right? And you go to East Point Municipal Court and you say, I want a trial. Well, East Point Municipal Court is not going to try your case. They will do what is called a bind-over to the Solicitor General's office, and we will then handle that case and try your case in state court. Some cases come directly to our office. And so those are things like family violence, batteries, gun cases. Those are going to come directly to us. They're not going to go through municipal court. They'll come in through the Fulton County Jail, and we get those cases immediately. One of the things that I do as part of my job in the Solicitor General's office is I work with the jail team. So I am the deputy chief over the jail team, which means that every morning at about 4 a.m., my team gets up. We collect any cases that have come through the jail in the last 24 hours. We go ahead and accuse those cases immediately. That was an initiative that Solicitor General Gamage pushed for during COVID to help prevent the backlog that was building up during the COVID pandemic. And then we go, after we have accused those cases, which just means formally charged those cases, we then go to court at around 2 p.m. and have those cases heard before a judge, and the judge advises the defendant of the charges against them, and here's the issue of bond. So we are moving those cases very quickly through the system so that individuals' rights are not suspended while they're just waiting in jail for some kind of resolution. It's in order to resolve the cases at the earliest possible time.
So is these cases, because when it comes to jail, I'm a little slow. So is those the cases like, just say I went to Walmart this weekend and decided to steal me some buttermilk? Those are the cases that happen over the weekend? Okay.
Yeah. Yes. The cases we see most over the weekend are usually family violence, battery. So what we describe as intimate partner violence, husbands and wives, parents and children, people who are dating and living together, where one party strikes or hurts the other person and causes bruises or injuries. Those are typically the types of cases that we see from the jail. We also have DUIs sometimes over the weekend, where individuals are driving, had a little too much to drink, shouldn't have been driving, and they get picked up. We do sometimes get theft by shopliftings, which is what you described, where somebody's just stealing from a store. But more often than not, the cases we normally see coming through our part of the jail are family violence offenses and cases involving guns. That is a huge problem, as you know, in Fulton County, where people are discharging weapons inappropriately. That person, had a little too much to drink on the 4th of July and is shooting a gun up in the air, or shooting a gun through somebody's doorway, and that kind of scares everyone, and that person is taken into custody, or is just carrying a gun in a place they're not supposed to be carrying a gun, such as bringing a gun into the courthouse house or bringing a gun into a place that is prohibited. So there are areas where you're just not allowed to bring a handgun. And if you are bringing a handgun into those areas, you will be arrested.
Oh, wow. Okay. Let me ask Judge Leftridge, are the court cases moving quickly now since COVID is partially over through the court system, or are they still lagging along?
We still have a backlog, but I think that we're moving through it very well as a court. It's interesting that you would ask that, Ms. Chapman, because last week I had my first opportunity to swear in a double grand jury. DA Willis is continuing that process of sort of, taking care of some of the criminal backlog by having two grand juries working at the same time. And so we're still doing that. And of course, after those cases get indicted, they come to, I guess that would be 14 of us, because 4 of us are, like Judge Farmer, in family, and we have one chief who is not taking new criminal cases. So they're divvied up between all of us. And so we're continuing to grind. And we're also doing the same, with our civil dockets as well. We are clearing out our backlog, I think, with deliberation. I'll say that. And, there was we just had this, and we're still kind of going through this cyber attack situation. And with respect to that, and in an effort not to lose ground, it affected our filing system by way of example, as well as our phone systems and everything else. And there were conversations and meetings that were put in place to make sure that we didn't lose ground during this time, because we still have people filing actions and we still have criminal matters that we need to be able to get assigned and moved. So I think that we have taken overall a very proactive approach with respect to the pandemic and the continuing backlog and overcoming the obstacle of this cyber security attack.
Okay. Judge Dunaway, let me ask you a question. If I get charged with something and come into Superior Court and you guys hadn't looked at my case in 5 years, what happens?
Wow, 5 years is a long time. Yeah, that shouldn't take that long. It shouldn't take that long, 5 years to handle a criminal case. I have one really old case, and that's because we could not get a defense attorney to handle the case, so it's sat waiting to get a defense attorney to handle it. But my goal at this moment is to a year, 18 months at the longest to resolve these criminal cases. If it's it might be maybe 2 years on. But yeah, a year to 18 months seems to be that's my standard. And if it's taking longer than that, definitely if the person needs to make sure they've contacted their lawyer and that their lawyers talk to the DA's office and that the lawyer and the DA are talking to the judge and the judge's staff to get that case on a calendar and to get it moving. 5 years is a long time. Yeah, that
okay, let me
hurts my heart.
Oh, let me ask you this, because I don't know, so I'm asking. If I come before you guys and with a serious crime, don't have no money, do you guys appoint me a prosecutor? How does that work?
There is a state agency, that actually handles indigent defense for the state and for Fulton County. And that state agency funds and hires lawyers for each circuit. And here in Atlanta Judicial Circuit, we do have the circuit defender, also known as the public defender. And the circuit defender, they have at least 2 attorneys in each of the criminal courtrooms. And so if a person falls below that income level, they qualify for the circuit defender or public defender, they will be appointed through the state agency, a circuit defender or public defender. And I know Kevin mentioned earlier the conflict defender's office, and so that people understand that because we are getting more cases where we have a larger number of accused on one indictment. Let's say we have 5 people on one indictment. The Fulton County Public Defender's Office will handle someone. And then if another person needs a lawyer, we have a Metro Conflict Defender's Office. They can be appointed to handle that person. And then it's where we get into some delay is once you get outside that first and second level, that get to that third level, we call it third level conflict. The state is contracting with lawyers to handle those cases. There's a shortage of people who want to contract with the state to handle those cases of the third and fourth level conflicts. So while I might have 2 people represented, one by the public defender's office, one by the conflict defender's office, I still have 3 other ones who might be unrepresented while they work on getting a contract or getting someone to represent that person.
Could I say something, Ms. Chapman?
You sure can.
I just want to piggyback again off of what Judge Dunaway said. Everybody gets the right to have their own lawyer. And so we have one case, but we have 3 co-defendants, and we can't, you know, the law says that everybody gets their own lawyer. So that is why we have to go through the levels that Judge Dunaway was talking about, because, you know, the law doesn't make folks share an attorney. And one of the reasons for that, if not the chief reason, is because they might be pointing the finger at each other. You know, I didn't do it. My co-defendant did it. One person can't represent well the interests of 2 people or 3 people or 4 people who are all pointing the finger at each other as, you know, saying it's the other guy that did it, you know.
Okay, that makes sense.
And Ms. Chapman, if I may,
Yeah.
I will also say that a public defender is always appointed to an individual who is in jail. So if that person is arrested, let's say you're arrested on a Friday, you are appointed a public defender who will represent you while you were in the jail. And so oftentimes as early as the very next day when our cases are going to that first appearance that I was talking about, where they're advised of their charges and they're given a bond, there is a public defender with them at that time. And so I just wanted to kind of just say that because it applies to both misdemeanors and felonies, where you do have that right to an attorney at the earliest possible moment. And that is literally from the time you're arrested and put into jail, you are represented and assigned a public defender to represent you.
Okay, Judge Farmer, you got your hand up.
Yeah, I wanted to add on to Judge Dunaway and Judge Leftridge with the different layers with the public defender and the conflict and, you know, multi-defending cases. Unfortunately, usually when you get to cases that have 3 and 4 defendants, those are kind of by definition your more serious cases. These are not, you know, you don't get 5 co-defendant shoplifting cases. It's either, you know, it's a group that did armed robberies or home invasions, or they like did a murder together. So it's when you're looking for lawyers for those people, you're not looking for a first-year lawyer for those people. You're looking for folks that can go to trial and have some experience. And, you know, there's not as many of them out there that want to do that work on a conflict basis, on a contract basis. But that can be part of the delay, as Judge Dunaway, you know, so straightforward put it. It's the delay is there, but we do everything we can to, you know, to respect their rights. And you were talking 5 years. You know, there's a piece of the Georgia law that gives you, you know, you have a right to a speedy trial, and then the Constitution gives you, you know, you have to demand a speedy trial within such a period of time. But even if you don't, if it goes on for too long, it can be found to violate your constitutional rights.
Okay, I'm accessing, and anyone, you guys can jump in to answer the question. What do you do when you see repeat offenders or people that you know have a mental health that keep coming through the court system? I say as like a revolving door. What do you guys do with those people? Anyone can jump in.
So
Anybody want to jump on that?
I was
Y'all
about-
all can jump in on it. Go. You want to go first, Ms. Faulk?
Sure. So one of the things that we are proudest of in the Solicitor General's office is we have worked very closely with both PAD, which is the Policing Alternatives Diversion, as well as Misdemeanor Mental Health Court. And so PAD is a program we have been working with very closely with them over the last several months. And what we do is first thing in the morning, where my team identifies that there is a defendant who has some mental health issues or is experiencing being unhoused, and they need assistance in some way, and the crime is being essentially created by their unhoused status, theft by shoplifting because they're stealing food because they don't have a home, criminal trespass, they're sleeping on the front step of a hotel because it's safer for them than sleeping out on the street. In those situations, we absolutely divert that person into the PAD program where they can get assistance with housing, with mental health treatment, with those kind of services to help that person stay out of essentially the jail cycle. So they can break that cycle of them coming back into jail because of offenses that are essentially low-level offenses brought on by the fact that that person doesn't have the services they need. We also work with the Misdemeanor Mental Health Court and divert individuals into that court program. All of this happens, as I said, first thing in the morning. We're recommending these individuals into these programs so that they can get help with their mental health issues. And also our court has a competency program where if somebody is not competent, we try to find solutions to assist that person and get them assistance with medication and services in order to help them in that way too. And so Solicitor General Gamage, it is definitely one of the things he's passionate about, is trying to find creative solutions for very low-level offenses where we can get those people services and assistance at the earliest opportunity.
Okay. One of the judges, y'all want to piggyback off of her?
Well, yeah, I'll jump on that if nobody else wants to. As Ms. Fox said, there's an old saying that it's never good if the judge knows your name ahead of time. But the repeat offenders and folks that have mental health is a chronic problem in the criminal justice world. And to that effect, the Superior Court has, I think it's 4 different accountability courts. We have a veterans court. We have a behavioral health court. And even with the veterans, some of that is mental health because it's PTSD and folks self-medicating from whatever experiences they had in the military. So we have several different accountability courts to try and put people in a position where they don't have to break the law to eat or to self-medicate or to get housing. You're trying to put them in a position where jail isn't an alternative they don't mind.
Okay.
Because some folks that's all they know.
Okay. That's
unfortunately.
true.
So
That's true.
we do everything we can with the resources we have. And we have, there are different judges who are in charge of those accountability courts, and they meet with these folks. I think it's once a week, once a month, some of them. And they try and make sure that people don't fall through the cracks. It's not just puts upon on probation and they go away. It's the accountability court is part of their sentence, and it requires a lot more work on both the people's, the defendants' behalf and on the court's behalf, because we got judges that put a lot of time in outside their normal caseload to do this.
Okay. What you think, Judge Harris?
I think that when we are sentencing defendants in connection with pleas and with trials, one of the things we have, Ms. Chatman, is someone to read the criminal history off for us. It's either the prosecutor, sometimes it's the probation officer, or both. So they give us sort of the from whence this person has come to us history. And we take that into account when we decide whether or not to accept a negotiated plea or reject it. We take that into account when we are in the middle of and embarking upon a non-negotiated plea scenario. And that's a non-negotiated plea is when the prosecutor and the defense attorney get to shop their varying proposals to the judge. This is what I think the sentence should be. And then the other side says, well, this is what I think the sentence should be. And we are taking those two proposals into consideration and then imposing a sentence that may not be either of those proposals or could be. And a lot of what we decide to do in that scenario as well is based upon the person's criminal history. And then lastly, when we are sentencing after a jury trial, when the jury comes back and if the jury's verdict is that the person is guilty, and depending on the nature of the charges, we are able to take into account criminal history and whether there's some other filings that have been filed by the prosecutor's office, so forth and so on. So I think that we are definitely in a good position to try to tackle that overarching problem of recidivism when we do those things.
Okay.
And if I can add that
Come on, Judge.
our public defender, our circuit defender, conflict defender, that those offices do an amazing job. They have social workers, they have investigators, they have programs. I depend a lot on the public defender social worker to come up with when someone has a mental illness or some having some other type of crisis, for that office to come through with the program, be it Salvation Army or Metro Atlanta Reporting Center. There's so many programs that the public defender's office knows about. And I get people all the time say, "Oh, I don't want a public defender. I'm gonna get a paid lawyer or a real lawyer." I'm like, hold on. Now the public defender's in here every day. They know the prosecutor, they know me, and they got all the programs and resources to help someone out. So please, everyone be respectful of the circuit and public defender's office. They're working really hard, and they are the ones who have the programs that they present along with probation. They present to the courts and let us know that the client is having some type of crisis, so that we know who those people are and what we can do to assist when they're having that crisis. Now, on the other end of the spectrum, Judge Leftridge kind of touched on it. If you come before me and probably many of the judges and you're on aggravated assault number 3 and you've knocked somebody over and stolen their purse and you shot at somebody and you've done some of these armed robbed someone, broken into people's houses. What I've learned in my years on the bench, going from all over this county, from Alpharetta to Palmetto, is everyone in this county on all sides of the county want to be safe. They want to be safe in their homes. They want to know their kids are safe when they go to school. They want to be safe when they go to work, want to be able to put gas in their car and not have to worry about someone stealing their car. The fallacy is that, certain parts of the county, people don't care about being safe. They do. I'm from the city of South Fulton. The folk down there want to be safe also. They're tired of people breaking into their homes when they go to work. That revolving door of Fulton County, those days are over. I think this bench that we have now, and I tell folk, even in Fulton County, felony number 3, 4, and 5 might get you some time at the state system. That revolving door, I do believe that we're dealing with that. And I want the people to know that we understand that everyone wants to be safe in this community, and people that are aggravated assault, breaking into folks' houses, armed robbery, they are getting appropriate sentences. And many times that includes a prison sentence, a significant prison sentence, if the record and the crime dictates it.
Let me ask you, because sometimes people, when they house get broken into, they say, "Oh, I had a home invasion." It's a difference between a home invasion and breaking in. I know, but could you explain that, Judge?
Yes, yes. A burglary, a break-in, a burglary, is generally no one's home. No one's home, a residential burglary, no one's home. They come in when you're at work or on vacation. And everybody stop posting where you are on vacation. When you're on vacation, people, they're looking to know that you're not home. And when you're not home, they're breaking into your house and stealing your flat screen TV and laptops and tablets. That's the residential burglary. A home invasion is when someone's home and someone comes in with a deadly weapon. One of the worst ones I saw was two guys came in to a citizen's home with guns and ransacked and held the people hostage. When we speak of home invasion, that's what we're speaking of, coming in when someone's home with a deadly weapon.
And I agree. We and I thanks for saying that, because I remember maybe about 9 years ago we had a home invasion next to my home, and it was a home invasion. And so people, when houses get broken in, they say a home invasion. But again, like you say, it's a difference when it's a gun involved and you're at home.
Yes.
Let me ask you a question. How do you guys, and all you guys can jump in on this, how do you guys handle the HOA complaints that come before the Superior Court?
With care. It's amazing how much energy and passion and frustration folks have with respect to that particular area. So I think that we really want to put a lot of attention into handling those in a different kind of way, because of the energy level surrounding, those peculiar kind of cases. I'll say it like that.
Oh, yeah. And the reason I asked, because when I was the HOA president, I probably went down to Superior Court probably 4 to 5 times a month, and you'd be surprised. And so could you tell, usually it's money involved when you hit Superior Court, correct? Could you explain? Because sometimes people that lives in HOA, they think that, oh, we don't have to pay this money. And what I've always used to tell them is, you try to pay that money, because when you go before the judge, now you got court costs, you got all that extra cost. So could you kind of explain to people, when they come before the Superior Court dealing with the HOA, what kind of take place without crossing the line?
If you want me to take it, Melanie, I'll jump on that. An HOA agreement it's a contract. It's simply a contract, but it has to do with real estate. That's why it comes to Superior Court. If you're going to buy a house, I know there's this many documents when you buy a house, and you sign your name 800 times. If there's an HOA agreement in there, read it. Because I think I saw something, 87% of new housing, or in the high 80s, is covered by HOAs now.
Absolutely.
Because everybody used to say, well, just buy a place that doesn't have an HOA. Getting harder to find. I'm blessed. My neighborhood doesn't have an HOA. But it's a contract, and you think, oh, it's a homeowners association. It's for the benefit of the homeowner. Well, is it? The first thing we're going to do is because I want you to read it before you buy the house, because we're going to read it when we have the case. And it's a simple contract, and we're going to rule on the contract basis.
I used to say, Judge Farmers, when I was the president, I say that the covenants in your bylaws is just like their Bible. You got the norm, because if you don't, you. And let me ask you, because some people, they have this mindset, well, I didn't know what I was signing, but you're in that HOA. Well, I'm not going to pay. So y'all kind of help me with that, because I know some folks is watching this, got the same problem, and they probably thinking the same thing what I just said. I ain't gonna pay.
Ignorance of the contract is not generally a defense.
I like that. I like that.
I always say you wouldn't do surgery on yourself, so don't try to be your own lawyer when it comes to a contract. If you are not sure, especially when it's something as big as a house purchase, I mean, the housing prices are what right now? Median house prices in Atlanta, Georgia are $350,000, $400,000. That is a lot of money on the table. And just like you wouldn't grab a scalpel and say, I think I can remove my own appendix. I've seen it on TV. Don't try to read through a contract with detailed terms when you're talking about $500,000 of your life savings and your money that's on the table. Take the time to take that to a lawyer, have them look over the documents and advise you. It could truly save you hundreds of thousands of dollars in pain later on down the road.
Judge Dunaway, I'm going to ask you this. 9 times out of 10, when an HOA case come before the Superior Court, the HOA typically win. Is that correct?
I don't know the numbers or the statistics, but what I can say is, a lot of people think they don't have to pay the HOA fees because they have some issue with something in the community. Oh, well, the HOA didn't keep the grass cut, or they didn't paint, they don't keep the lights up. That doesn't negate their obligation to pay the HOA fees. Most of the time, the contract is you pay the fees and we'll keep up these common areas. So if the HOA is not keeping up the common areas or doing what they're supposed to do under the contract, I think the person is still obligated to pay the HOA fees, and then they can bring suit against the HOA for a breach of contract. So like Judge Leftridge said, these are contract cases, and we're going to read the contract and rule according to the contract. And if the contract says you're supposed to pay your HOA fees, then we're going to rule according to contract. And one of the ones a couple of ones I saw, that the covenant, the declaration allowed for the HOA to levy a lien against the person's property. And so now you have a lien against your property, and then eventually the HOA will look to foreclose on that lien possibly and take the property. So it's read the contract, get some help reading the contract, pay the fees. If you don't agree with what the HOA is doing, then you can bring suit. A homeowner can bring suit under the contract, just like the HOA can. But you don't want to be in that position where they're putting a lien on your property, and then at the end of the day, they are looking to foreclose and take your property from you.
Thank you. Look, I've enjoyed talking to you guys so much that I've truly lost track. It's 3:03. Give me a second of your closing before I want to thank you guys for taking out the time to come. We're going to be chatting again. Thank you guys. Judge Donahue, come on with your 2 seconds.
All right, thank you all. Thank you for having me. We are down here at your courthouse and we are working. Courtroom 4F is open. Please come visit me.
Thank you. Judge Harris.
Been an honor and a pleasure to be here. I always like visiting with you on your show, Ms. Chatman. Thank you for including me. All right.
Thank you. Judge Farmers.
Again, thank you for having me, Ms. Chatman. It's always a pleasure to see you. And while Judge Dunaway's down in 4F, I'm just 2 doors up in 4D. So I'd like to say, come on down and say hello. I know nobody wants to come down here, but we are also, nobody wants to be part of the case, but we are a public building, and all cases, all hearings are public. The doors are unlocked. You can come if you have If you don't know how court works, come watch. Then, you know, before your case comes to court, go watch the judge that you're going to be in front of. Try and get a lay of the land so that your first time walking into court isn't the day of your case. Kind of takes your nerves off, gets you ready for what's going to come. But we're open for business, you know, 5 days a week. We're here. So thank you for having me.
Thank you, Ms. Faulk.
Thank you again, Ms. Chatman, for having us. And I just want to one more time pitch Spring Clean 3.0, which is our record restriction and career fair. Come on down. Let us ring that bell for you when you get your record restricted. It's a great time. We invite the community to come down Saturday, April 20th from 12 to 3 at 3003 Howell Mill Road Northwest. And we are working Saturdays in the Solicitor General's office. So we are Monday through Saturday. So come on down on Saturday, April 20th. The number is 404-612-4827. Again, that's 404-612-4827. And we encourage the community to come down and get your record restricted.
Again, thank you guys for coming. We get ready for the next show. Thank you. You guys have a great day. We'll be watching again. Congratulations on the 2 judges that's don't even have no votes, but y'all come out and vote for them anyway. Thank you so much.
Thank you.
Thank you.